Many thanks for staying with us and welcome to another edition of Channels Beam. I'm Victor Matthias. Now, the president signed into law the Nigeria Data Protection Act into law in June 2023, thereby providing the legal provision for the establishment of the Nigeria Data Protection Commission. The act sets out its scope, the lawful basis for the processing personal data, and prescribes penalties for non-compliance with its provisions. On the show today, we will take a deeper look into the act as it operates side by side the Nigeria Data Protection Regulation. But before we kickstart the conversation, let's take a look at the social media trends in the past week.
Generally, to what he said is because he loves drama. Everybody knows that, you know. And what he's saying, he's daring nobody can suspend him and the rest. Believe me, the quietness of the...
This week's Top 5 kicks off with the pronouncement made by a member of the PDP that Minister of the FCT, Nyesom Wike, will be expelled from the party at the appropriate time.
He knows what he is doing. At the appropriate time, he will not only be suspended, he will be expelled.
And some people say suspend Wike, sack Wike.
It was followed in fourth by former governor of Ekiti State, Ayo Fayose, warning that the party will suspend Mr. Wike at its peril.
Extreme situation in differences is not to tell, say, drive your wife or drive your husband. Wike is a force in the PDP.
Suspects that we are parading today, we are still investigating, and I want to assure Deltans and Nigerians that...
Third spot sees the arrest of 67 gay suspects in Delta State.
Investigation. We are bringing this out to the world to know, especially Nigerians. We are in Africa and we are in Nigeria. We cannot copy the Western world because we don't have the same culture. We don't have the same culture.
I never hid my intention. As a PDP member, I came out that I'm going to support equity, fairness, and justice.
In second is Mr. Wike daring anyone to suspend him from the opposition People's Democratic Party.
Did we not say, look, you cannot as a party, if you mean well for this country, to continue with the line you are going, it means that we don't have a place in the party.
While the burial of 22 officers in Abuja takes the top spot in this week.
Well, there you go. We brought up the last for the first this time around. I mean, sometimes you have to move things around to make things work. But joining us to look at today's topic, we have joining us via Zoom, Omori Edogiawere. He is a startup attorney and a notary public of Nigeria with extensive experience in corporate and commercial legal practice. Thanks for joining us on the show today.
Thank you, Victor. It's good to be here.
Absolutely. We also have joining us from our Lagos studio, Timi Olagunju. He is a policy consultant as well as a tech lawyer. Timi, it's a pleasure as well to have you join us on the show today.
Thank you for having me, Victor.
Absolutely, you're welcome. So kickstart the conversation for us, Timi. So, I mean, we've seen that the Data Commission has, I mean, the Data Protection Commission has already kickstarted. I mean, they've already gotten off, on a good note. They're making sensitization, programs and all of this. But in essence, what exactly should Nigerians be expecting from this commission?
Well, to a large extent, the Act has provided the necessary foundation for the Commission to act within legal and regulatory bounds. And that's something quite commendable because before now we didn't have such a foundation. And so the Commission, as the Act provides, requires that within 6 months of the passing of the Act, as well as its assent, it will swing into full action in the sense that data processors and controllers of significance will definitely then have to meet certain requirements, which includes the provision of data protection officers or auditors within its frame. So we'd expect that the Commission would start to work towards setting guidelines in terms of what controllers, data processors, and controller of significance will definitely mean, what criteria will be the basis for allocating such individuals. And also in terms of capacity, one of the key challenges that has been discovered with the commission is the fact that will it have the capacity to deal with the humongous work that is going to be before it. And so in that regard, in terms of capacity, the commission might start looking at where it needs to fill the gaps, cross the T's and dot the I's in terms of the necessary capacity to carry out its function across board as it stands. And some things in the Act as well, I think the Commission should look at is something that has to do with the age of consent, which is a bit not too clear, because Section 31(5) talks about the fact that 13-year-olds have the right to consent to their data being processed. But then the Act also spells out that the age of a child is as defined in the Child's Rights Act, which we know is 18. So the Commission might need to clarify as to some of these key issues, as well as other key issues in the Act going forward.
Yeah, I think that's actually a thing of worry for me, the age thing. Because there needs to be specifics, especially in terms of that. Like you made mention, there is this disparity, of what the Act says and what the Child Rights Act also says. So hopefully the Commission would find a way to bridge that. But let me quickly get to hear from Omori, who is joining us via Zoom, as to how this will run, because we also have the Nigerian Data Protection Regulation also running side by side this. How are they going to coexist in the ecosystem?
Victor, can you hear me clearly?
Absolutely.
Okay, I wasn't privy to what my brother Timmy said, so I may not be able to speak to some of the things he has pointed out, and I hope I don't get repetitive.
Yeah.
But so the NDPR and NDPC are one and the same, so it's essentially just semantics and change of name. The Bureau has transited to now becoming a commission, and then the regulations more or less been subsumed into the Act. What we're going to see is, and this is what I think has happened. So the regulation focused primarily within jurisdiction, Nigeria, focused on Nigerians, natural persons living in Nigeria and Nigerians living abroad, right? But the Act takes it further, right? And is focusing very importantly on the management and applicability of data, not just of Nigerians in Nigeria and Nigerians abroad, but of all entities that are dealing with data that have to do with Nigerians, right? And so I think there's going to be a fine marriage of the regulations and the Act. I would have felt that what would have been better would be really to work extensively and have an Act that will clearly, continue from where the regulations have stopped, right? But if you really look at the Act, the focus on the Act is predominantly on data control, right? Management and utilization of data, especially from the angle of the third-party entities that are utilizing and processing data from this end. So I don't think there's going to be much of a conflict. I really don't even think there will be conflict, because the implementation is going to be an enforcement will predominantly be with the NDPC, which is essentially the same, which was the NDPB at the time when the Act was not enacted. But I still think that, there's still some haziness, right? While the Act really deals with key things like legitimate interest, which the regulation did not, it's important that we again look at some of the gaps in the Act, and which is in some instance the failure or problematic definition of certain key terms under the Act, which the regulation also was quite silent on. But In terms of conflict, speaking to your issue, which is whether there's going to be an issue, I do not think that there will be an issue, because what creates conflict oftentimes is in the execution and implementation. And if the same person who created both is legally empowered to ensure the applicability or enforcement of both, I do not see what the issue would be. But I think that it would have been neater and a tidier arrangement to have a more holistic act that clearly encompass all the provisions of the regulation, as well as improving on it to bring in other things that were not initially ascertained by the regulations. But as it is, I think both of them can still work hand in hand. Like I said earlier, the Act is predominantly focused on ensuring that data processing and utilization of data are ethically and properly done. And I think that the game changer for me, what I'm very excited on, is adequately addressing legitimate interest and creating a clear assessment for delineating what legitimate interest is. Because the issues that we have been bedeviled with when it comes to data management and data processing is the haziness and the lack of certainty as to what really constitutes legitimate interest, and if the deployment of data, by business entities, by third parties, by companies, have been, legitimately deployed.
Yeah.
But all in all, I think that there's not going to be a conflict.
Well, let's hope so. But let me just quickly take us through some of the things that are listed in the commission, which would be actually the role of the commission. Now, they say this commission is supposed to foster the development of personal data protection technologies in accordance with recognized international best practices and applicable international law. It will also conduct investigations into any violation of a requirement under the Act, also impose penalties in respect of any violation of the provisions of the Act or subsidiary legislation made thereof, where necessary, accredit, license, and register suitable persons to provide data protection compliance services. Now, they will also issue regulations, rules, directives, and guidance under the Act and register data controllers and data processors of major importance. Now, Timmy, let me come back to you, especially, on the last role of the commission, which is talking about registration of data controllers and data processors. Like you said, the issue of capacity, and what criteria would be used is what has given you some form of concern. And like I said, also, the age thing also gives me some form of concern. But let's even begin to think of ways in which, these gaps can be bridged. What do you think can be done to bridge some of these gaps, especially capacity, which is very important at this point?
The commission is listening. I think one of the key opportunities is the fact that, as you know, the World Bank is pushing actively in partnering with the Nigerian Information Management Commission to develop some kind of digital identity, ID, for Nigerians. And that's a key one. And there's a certain funding available around that kind of initiative or project. And so for me, I think that the commission, that's the National Data Protection Commission, can key into that kind of funding towards developing its capacity, both short-term and long-term, in the sense that, look, if we do not have data adequate protection, and the commission is not adequately empowered to protect data subjects, Nigerians and residents, then Nigeria has no business in terms of developing digital identity, because you can't develop digital identity without trust, right? So the commission is key in terms of ensuring that, data protection is key to be able to build trust for projects like that in Nigeria. And so I think it can tap into such funding, because fund is fundamental to fund any mental thing, towards the development of capacity through scholarships, right? I know that NIDA, for example, has taken an approach a few years ago towards partnering with local indigenous universities, like the Faculty of Law in UNILAG, towards developing courses like courses in cyber law, right? So I think it's important that the Commission, in developing indigenous capacity, invest towards scholarships and partnering with local institutions within Nigeria towards developing capacity for the Commission going forward, or else it will not be able to achieve its goal. Another thing is
its goals.
Yes, it's in. I mean,
I was just trying to lean out. Hello, Timmy. I was just trying to lean on some of these recommendations that you're making, and I quite agree that yes, these partnerships need to be struck, so that one way or the other they can form this leeway of making capacity available so that they can actually achieve their aims as well as their objectives. But let me just hold you there for a bit. Again, I'll come back to you in a moment. We need to take a break. And of course, we'll get more of these recommendations. That's in a moment. Please stay with us.
Following the suspension of Nigeria Air Project by Minister of Aviation and Aerospace Development, Festus Keyamo, some Nigerians reacted hailing the decision and calling for the probe of the setting up process of what, according to them, was more like a castle in the air. Another African nation saw its democracy toppled by military officials as the president of Gabon, Ali Bongo, was locked and separated from his family. Pushes in the Central African country. A video of him later emerged where he urged his friends to make noise and ensure his mandate is restored.
Many thanks for staying with us. We still have with us our panelists in the Lagos studio as well as via Zoom. But just before we took a quick break, Timmy was actually giving us some recommendations as to what the Nigerian Data Protection Commission can do, in terms of building capacity to ensure it carries out its work. Timmy, you were talking about partnerships, which I was talking about, in terms of, or reiterating, like you said, partnering with universities, looking for scholarships, and all of these. But what more do you think can be done?
Absolutely. That's the key point you raised. I think because those who forget history are doomed to repeat same. So I'm trying to recommend what has been done in other sister agencies for the commission to take on as a recommendation, not something out of the blue. Another recommendation will be something that this commission, the commission that is in charge of consumer rights, right? The commission has done so far. As you know, that the commission in charge of consumer rights has been very focused around this fintech companies that are always harassing people, debtors, as it stands, right? And so you realize that it focused its approach, its policy approach towards dealing with a core priority, which is loan companies that harass debtors. And that has been quite effective for its PR strategy, as well as in terms of its accomplishment. I think that the commission can take a cue from that and follow a simple logic in economics, which is called the scale of preference. And for the next 2 to 3 years, whilst it's developing capacity, focus on key areas, 1 or 2 key areas within the data protection space that it wants to deal with. Does it want to deal with data protection basically around, communication? Or does it want to deal with data protection around the information space? Or does it want to deal with data protection around technology itself, software and hardware? It needs to focus on the first 2 key areas it wants to focus on so that it can, within its capacity, achieve tremendous progress going forward. rather than just being everywhere in that sense, whilst it built capacity.
Yeah, I quite agree. I mean, moving forward, we'd like to see, wins being recorded. But let me hold you there for a bit and, just get to hear from Omori. Omori, you talked about, some haziness, so to speak, in the act. And I was thinking, what are those gaps? What are those unclear, terms that you have seen that needs to be addressed, for the commission to carry out its obligations?
Thanks, Victor. Starting point is, first of all, we need to know so there's no clarity as to whether or not the NDPR, the extent of, yes, Section 64 talks about the fact that all other rules continue prior to the enactment of the Act continue to exist and all that, right? But there is no clarity as to really if it exists or not. So we are only, giving some measure of interpretation to Section 64 of the Act, right? Which, in essence, gives life to the NDPR prior to the enactment of the Act and ratifies everything that has happened up to the extent. But I also know that in the future, especially as regards its application, there may be certain discrepancies or issues relating to which of the rules apply. Even though the Act leans more heavily towards appropriate processing of data and utilization by third-party companies and all that, right? But it's also imperative that we address those issues. However, I know Timmy had mentioned it, but the definition, so for instance, the definition of a data subject is quite problematic. And it's very, very important that, maybe the amendments of the Act should reflect a more holistic and a tidier definition. Because what you're going to have is definitions that are susceptible to different interpretations because it's not holistic, right? The issue of consent, there's some discrepancy between whether it's 13 years or 18 years. If we do not address those issues, there's going to be a major inconsistency issue between the Act and the Child's Right Law. But in implementation, I'm very concerned and wary of the ability of the Commission itself to adequately, emphasis on the word adequately, implement the provisions of the Act in terms of capacity building and in terms of reach, oversight, especially when we're talking of collaborative relationships with other relevant
sister
agencies in that space. Because, for instance, our data management system in this country is far from being where it should be, right? There's still a lot of inconsistencies. There's still a lot of fragmented approaches given by different ministries or MDAs, right? And it's important that, first of all, I think that for any data application and enforcement to be effective and cross-board in this country, there has to be a seamless and a symbiotic relationship between the NDPC and the NIMC.
Yeah.
And if that is not done, then we're far from where we should be.
Omori, one would argue that, I don't want to call them baby steps. I mean, let me just say we're moving in the right direction. I mean, I want to believe that you would agree with me on that.
We're moving in the right direction.
In the right direction. So let's instead of saying, baby step, I'll say teething problems. I mean, they're almost one and the same.
I don't think we've even gotten to the teething issues, the teething problem, right? I'm looking forward to the Act facing solid judicial scrutiny.
Yeah.
I'm looking forward to jurisprudential interpretation by the courts of the provisions of the Act. Giving life really to it, because a lot of what we are doing is still, I would want to say speculative for want of better language, but it's still in the realm of, primary application.
All right.
But by the time enforcement starts and people start approaching the courts for interpretation of the provisions of the law, applying them to factual cases, give life to them. Then we can really start talking of the teething issues. Especially imagine where if we have a judicial issue regarding the issue of consent, whether consent was appropriately given, by a 13-year-old, or whether
not.
A 13-year-old is incapable of giving consent, even if the Act provides such.
Well,
I would like to see that.
I equally would like to see that. I mean, interesting times lie ahead. With the implementation, by the Commission. Yeah, exactly. I'm glad you agree with me on that. As we always say, time will tell. I have to say thank you to you for joining us now, on this via Zoom from Lagos. Timmy, let me just give you 30 seconds to wrap this conversation for us. In terms of implementation, again, what do you think you would have loved to see that, isn't in the Act? Quickly, please, 30 seconds.
Okay, so, well, first thing is the fact that, Section 34 to Section 38 talks about the rights of data subjects. That your right, my rights. I think it's important that we begin to emphasize education about data rights. And also, one of the key challenges with that act is also the fact that which court of law do you actually institute, enforcement of such rights? That might be a subject of jurisdiction and debate going forward. But also going forward, I want to see that our parliament, this is a call to the National Assembly, that we also ensure that the Digital Rights and Freedom Bill becomes act to give more life to the rights of data subjects in Nigeria. Yeah. Thank you.
Absolutely. Let's hope that happens, in the not too distant future, especially as things are moving in the right direction. But I have to say thank you as well to you, Timmy, for joining us on the show and sharing your thoughts as well. But that's where we wrap it up today on the show. Thank you so very much for watching. Be mindful of your data, protect yourself, and of course, if any violation happens anywhere, be assured that that rights can be taken up. That violation can actually be, have a legal backing in the court of law. But thank you so very much for watching. I'm Victor Matthias, and it's bye for now.